stand on the subject. Apart from supporting what my learned colleagues have stated with respect to the reconduct of the exam, my lords, I am also challenging the fact that 1563 students, my lords, were asked to sit for a retest on the 23rd of June. According to me, my lords, that classification or computation of 1563 students, my lords, is totally faulty. And I lay good my submissions on this, my lords. I'm in petition number 384, my lords, writ petition number 384. And if my lord comes to the notification dated the 5th of May, 2024, my lords, which is annexure P3 in my petition, my lords, 3.36 at 384 of 2024. This notification, my lords, crystallizes the problem that was faced on the day of the exam. And this is only one single solitary notification by the NTA, my lords, on the evening of the day of the exam, accepting the fact that only one center at Savai Madhopur, involving 120 students, my lords, was the cause for concern. Now, from the 5th of May, till the 6th of June, which is 2 days after the declaration of the results, my lords, from the 5th of May till the 6th of June 2024, there is not a single testimony by the NTA, my lords, in its website, which it keeps updating every day with respect to students who have been affected at the respective centers. The question I pose unto myself, my lord, is if, as on the date of the exam, the NTA came out with a figure of one center at Savai Madhopur involving 120 students alone, the question I ask unto myself, my lord, is after declaration of results on the 4th of June, how has the NTA come to compute the magical figure of 1563 students? That's one question, my lord. The second question is that I ask unto myself is, should in case this figure of 1563 students as put out by NTA be taken as genuine, then the next questions that this honorable court will have to ask of them are, does the 1563 students constitute a particular area in these three names that have been spoken about? Or do the 1563 students, my lords, constitute from all over the country? If they constitute from all over the country, my lords, it is indeed a systemic failure on the part of the NTA, which they have brushed aside under the carpet deliberately, my lords, pulled wool over everybody's eyes. And had it not been for the outpouring of grievances that came from the students on the 4th of June, my lords, even this fact of 1563 would have been suppressed successfully. Now, with respect to the exam restricted to 1563 students, my lords, the question of law that I wish to point out to this honorable court, my lord, is if my lord has only for a moment the National Medical Commission Act.
The petitions challenging that have been dismissed by our court.
Sorry, my lords?
Petitions challenging the retest for the 1563 that they have been rejected by.
Yes, that could not have been done for those 1563 students. And the reason for that is, my lord, section 14. It has not been rejected. It was only said it will be heard later. Notices were issued.
That application is pending.
It is pending.
Notice on that application challenging the re-examination.
And tagged it along with the main issue, my lord. So the issue is still pending alive. It's simmering, my lord. If my lord now has only for a moment section 14 of the National Medical Commission Act, and my lord may just be permitted to help me. Yes, my lord, just come. And may lord just be permitted to read this? Section 14, my lords. My lord is with me? It says there shall be a uniform national eligibility cum entrance test for admission to the undergraduate and postgraduate so and so exam. I only pause here for a moment, my lords. The fact that the statute specifies that there is only one exam, my lords, for the academic year 24-25. We have already only for a moment the National Medical Commission Act.
The petitions challenging that have been dismissed by our court.
Sorry, my lord.
Petitions challenging the retest for the 1563 that they have been rejected by.
Yes, that could not have been done for those 1563 students. And the reason for that is, my lord, section 14. It has not been rejected. It was only said it will be heard later. Notices were issued.
that application is pending.
It is pending.
Notice on that application challenging the re-exam
And tagged it along with the main issue, my lord. So the issue is still pending, like summary, my lord. If my lord now has only for the moment section 40 of the National Medical Commission Act, my lord may just be permitted to help me. Yes, my lord, just come. And my lord, just be permitted to read this. Section 14, my lord. My lord is with me. It says there shall be a uniform national eligibility come entrance test for admission to the undergraduate and postgraduate so exam. I only pause here for a moment, my lords. The fact that the statute specifies that there is only one exam, my lords, for the academic year 24-25. We have already seen two exams, my lords. One held on the 5th of May 2024, and the retest, my lords, which has been done on the 23rd of June. Now, technically speaking, my lords, if there is one exam that is contemplated by the statute, my lords, and this is the statute that governs the entrance exam, if there is one exam that is contemplated by the statute, my lords, then the very holding of a retest, whether it be 1563 or whether it be n number of students, my lords, the NTA does not have the power, would not have had the power, does not have the power, my lords, to do a retest for the limited number of students that it has done on the 23rd of June. And insofar as the NTA June, my lords, results of which were declared on the 30th of June must be set aside, my lords. The third aspect that I wish not have come as on date, my lords, within the 50th percentile. But then the difficulty is of their own creation, my lords.